right, everyone, can I have your attention, please? My name is Daniel Fields. I'm the chair of the New York Law School Moot Court Association. At this point, without a doubt in my mind, we'd like to thank all of this year's competitors for sacrificing so much of your summer to write this brief and to dedicate yourself to this competition. And the proof is in the results. We saw amazing talent these past couple of days. So there's without a doubt in my mind, we thank you. And a round of applause is deserved for all of you. What you guys see right now is just one very small piece of this massive collaborative effort. This final competition, it's a very exciting day, and we're going to see some great things today. But what you guys don't see was the day in, day out grind that Christine Majori and Danielle Labrandi put in this summer, sacrificing their entire summer to write this exciting fact pattern, to the executive editors, to going through this process with them to make sure that the fact pattern was as strong as possible. That's Alexa Benaros and Daniel Cohen. To the vice chair of this organization, Darley Moth, for dedicating so many extra hours to make sure that this competition lives up to its reputation. And this reputation is this just exciting constitutional law fact pattern that exhibits just all these great competitors and determined individuals who want to make this team. And of course to Marbel Munoz, our public relations and media chair, for just all of his effort he's put in to this competition as well, and the rest of this e-board, who's just done an amazing job to making this competition be what it is this year. We'd also like to thank Professor Abraham, the faculty advisor, for helping us through this process, giving us just great assistance, and again, allowing us to be where we are today. And we'd like to thank Dean LaPiana and the rest of the New York Law School administration for their continued support and everything they do for this association. But there's two women I'd be remiss if I didn't thank, who just from day in, day out did everything they could from this competition the entire summer, from getting judges to producing the brochures to just every minute detail you can think of for this competition. There was never a single complaint, and they just did what they had to do. And that's what this organization is all about. So without a doubt in my mind, I have to thank Stephanie Rodriguez and Elizabeth Landon for everything they've done. And I'm going to introduce them right now. So come on up, ladies. And a round of applause for them.
Welcome, everyone. Welcome to the 39th Annual Charles W. Froessel Moot Court Competition. Before we begin, can we please give a round of applause to all the competitors who worked tirelessly throughout the last 4 days and are here now. As Froessel co-chairs, we have had the pleasure of coordinating this year's Froessel competition. It has been rewarding to have the opportunity to motivate students to explore their talents and collaborate with the legal community.
We would now like to thank everyone who has helped to make this competition such a success. We thank Danielle Labrandi and Christine Majori, the 2015 Froessel co-authors, for their intellectual and creative efforts that have inspired the future members of our Moot Court Association. We extend a special thanks to Professor Nadine Strassen for sharing her wisdom with us and in developing this year's fact pattern.
We also greatly appreciate the dedication of the Moot Court Chair, Daniel Field, and the Moot Court Vice Chair, Darley Ma, for going above and beyond to ensure this competition was a success. We also thank our Public Relations Chair, Marbel Munoz, for ensuring that every competitor was informed of every detail of the competition, and for making sure that the scores were submitted as quickly as possible. A special thanks to our executive editors, Alexa Benaros, Daniel Cohen, who proofread, rewrote, and published every single publication made by the Moot Court Association, including the brief, the bench brief, and all the emails you guys received this summer. We also want to thank the entire Moot Court Association and its members, because without you, Froessel would not have been a success. Round of applause.
We also want to applaud our faculty and administration for their continuous support, especially Dean of Academic Affairs, Dean LaPiana, who is joining us today. And last but not least, we would like to extend our sincerest gratitude to our faculty advisor, Professor Susan Abraham, and our Moot Court coordinator, Christy Cunningham. Without you, none of this would have been possible. We thank you for your guidance and direction throughout this process.
And now we will have the pleasure of calling our Froessel authors, Danielle Lebrandi and Christine Maggiore, who will provide a brief overview of the facts surrounding the case Alexa Bonaros versus United States.
Hi, everyone. The Islamic State of Iraq and Kazakhstan, also known as ISIC, an Islamic extremist terrorist organization that emerged as a subsect of al-Qaeda in Iraq in early 2013, is responsible for the mass murders of thousands of individuals, including American citizens. In 2013, ISIC began a campaign against the United States by coordinating, funding, and encouraging attacks on schools, churches, and other local community targets. These domestic attacks, all indisputably in support of ISIC, have both become more frequent and more lethal. Every attack has involved American teenagers between the ages of 13 and 19, who have either successfully detonated homemade explosives or at least attempted to do so. Following the most recent terrorist attack on April 1st, 2014 in New York, police authorities reported that every attack on American soil was coordinated through a social media application known as Glimpse. Glimpse is a social media cell phone application that was created to offer a more secure platform of communication than basic text messaging. Glimpse allows users to send videos which are deleted after 10 seconds. Glimpse can be sent from friend to friend or uploaded as a story, which becomes publicly available. Stories are also deleted after 10 seconds. There are an estimated 25 million daily users with over 200 million glimpses sent every day. Glimpse publicly acknowledges that it stores all data within the preceding 5 minutes in a central repository. Glimpse also acknowledges that it eventually deletes all content data. Other key features include viewer selectivity and screenshot notifications. The viewer selectivity function allows Glimpse users to choose who can view their videos or messages. Users can sort through their friends into groups and send glimpses only to those in the specified groups. Sorting users' friends into groups allows users to limit the sharing of their transmissions with only those users specifically designated, which makes such messages unavailable for public viewing. The notification feature informs users if a recipient has taken a screenshot of their glimpse. Alexa Bonaros has been an active Glimpse user since Glimpse's inception. Bonaros posts approximately 5 to 10 Glimpse stories a day and sends almost 45 glimpses daily to either her individual contacts or groups. Her Glimpse friends list is comprised of 100 people and is divided into 17 different groups. Because Bonaros is outspoken about her political and religious views, she separates her friends into groups in an effort to avoid offending any individual with her postings.
3 days after the April 1st, 2014 ISIC attack in New York, President Field issued Executive Order 41019. At a press conference, President Field announced, "Pursuant to this executive order, I am directing our counterterrorism agencies to explore new channels of communication in an effort to combat ISIC." Approximately 1 year later, on February 14, 2015, Evan El-Assad, a former employee of Glimpse, posted a 3-minute video to Froessel Times exposing what he referred to as the Lanza program. Mr. El-Assad revealed that under Lanza, the federal government has collected every piece of metadata communicated through Glimpse in the last 8 months. He did not provide specific details about Lanza, but did state that the program collects metadata in the exact same manner as the telephony program. 1 week later, the Froessel Times confirmed from 2 internal sources at the National Security Administration that Lanza was in fact created in response to the homegrown terrorist attacks by American youth. The Times also confirmed that the NSA has indiscriminately collected all domestic metadata created and transmitted through Glimpse on an ongoing daily basis. President Field immediately responded to these reports. As President of the United States, it is my duty to uphold the Constitution and to protect American citizens. Since 2013, our nation has been victim to an increasing number of domestic terrorist attacks. These programs are necessary to protect American lives. Although these programs are classified, Congress is regularly briefed on the actions taken to combat domestic terrorism. They have been repeatedly reauthorized by multiple Congresses under multiple presidents. Additionally, Congress ensures that any action taken under these programs have consistent judicial oversight. Some members of Congress were appalled by these revelations, while others made public statements in support. The Times also released a nationwide social study that began after the attacks on September 11, 2001, known as the Munoz Report. According to the report, in 2007, 71% of Americans believed that their electronic communications were subject to government surveillance. The report also found that in 2014, 62% of American citizens believed that their electronic communications were not subject to government surveillance. The findings were based on data collected between 2001 and December 2014 from a sampling of nearly 65,000 people each year. Although specific details of the alleged Lanza program currently remain classified, the government has concluded that, pursuant to Order 41019, the NSA is directed to collect all domestic metadata on an ongoing daily basis, which is created and transmitted through glimpse. On March 1, 2015, Bonaeren's filed suit against the federal government, challenging the constitutionality of Order 41019 under two facial challenges. First, Bonaeren's argued that the NSA's domestic collection of video and image messaging metadata created through the use of glimpse is unconstitutional because it is outside the scope of both the AUMF and Section 215, and it is also not within the President's inherent constitutional powers. Second, Bonaeren's argued that the government's intelligence gathering of domestic metadata of millions of American citizens violates the Fourth Amendment, which protects against unreasonable search and seizure.
We will now ask everybody please turn off their cell phones, make sure they are silent. We will begin the final round. This year we are pleased and honored to have the following judges: the Honorable Joseph E. Irenas, the Honorable Joel E. H. Slomsky, and the Honorable Fabiola Soto, as well as the Honorable Susan J. Abraham.
Oyez, 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 all ye having business before this honorable court draw near, and ye shall be heard. God bless the United States of America and this honorable court. The Supreme Court of the United States is now in session. Justices Abraham, Slomsky, Soto, and Chief Justice Arenas are presiding.
Everyone, please be seated.
May I approach?
1 minute, please. No. I'm asking for one of the coordinators.
We need 1 minute.
Judge needs the competitors' names. Could you write them for everyone? There's no name cards. We need the name cards for competitors. So write them.
Yeah, how do you pronounce that?
Cosme.
Cosme. Mauk.
Just say it.
Cosney. Okay. Wait. The Supreme Court of the United States is now in session. Will the petitioners identify themselves?
We are the petitioners, Your Honor. We are the petitioner.
Yeah.
May I?
And you are Mr. Cosney?
Yes.
Okay.
May I approach Mr. Chief Justice?
Yes.
Thank you.
Are you going to reserve any time for rebuttal?
Yes, Mr. Chief Justice. I would like to, with the court's permission, I would like to reserve 1 minute for rebuttal.
Okay. You may proceed.
Thank you. Good afternoon, Mr. Chief Justice, Your Honors, may it please the court. My name is Ronald Cosme, and I, along with my co-counsel, Molly Mock, will be representing the petitioner, Alexa Boneros, on this appeal. This case presents the court with a unique opportunity to end the president's blank check power to collect and store metadata. This program operates against every user of Glimpse continuously and indefinitely, contrary to the will of Congress and outside the scope of the president's exclusive authority. To prove that point, I will make 3 arguments before you today. First, the statutory framework and plain language of the authorization to use military force support the presumption that Congress did not implicitly authorize Order 41019. Second,
But our president is the commander-in-chief. Doesn't that give him authority to protect us in this on this issue?
Yes, Your Honor, to an extent. The president does have the authority to combat the war on terror. However, at distinction here is a wholly domestic affair. And the president has more.
How can you argue it's a wholly domestic affair when the whole reason for the danger that the government has put forward is that these are terrorists connected with ISIC, an international group, and international terrorism?
Yes, Your Honor. This is ISIC is an international group. However, what the government is collecting here is the communications of law-abiding citizens. Specifically,
they're not always law-abiding when they're committing acts of terrorism and people are dying and many other thousands of people are injured. Is that law-abiding?
Well, Your Honor, in that case, no, would not be law-abiding. However, I would point to the facts at issue here. Specifically, the government initiated Order 41019 after the attacks happened. Here in the record, there's no evidence that the government has identified any targets related to ISIC in their collection and storage of the metadata of Glimpse users. Arguably, you can argue that what they're collecting here is just simply American communications. There has been no indication of any further communications regarded or found by ISIC.
Wouldn't Glimpse be used by other wrongdoers, not just international terrorists, but fraudsters and con artists and crooks of all kinds could be using Glimpse? Even though most of the users would be lawful, but not just ISIC users. It could be all kinds of other fraudulent users. Indeed, you might presume that's true.
Mr. Chief Justice, you make a good point, and absolutely, there can be other interceptions of other activities that are against the law, and the president looks to Section 2 to the AUMF to support his presumption that Congress implicitly allowed that. What they're doing here is a slippery slope. They're looking to gain communication. They're looking to get access to communications from citizens who have not been identified and have not actually taken any effort to support ISIC.
But we know that there's been several teenagers, and the government does have information, who use Glimpse and have been engaged in terrorist activity.
Yes, it has in the past, and I would like to, if I may, Your Honor, I would like to point the court to the purpose of the AUMF. Initially, when the AUMF was passed, the Bush administration intended for it to be broadly interpreted. This is evident in the initial proposal, which reads, included the broad-based authority to deter and preempt any future acts of terrorism or aggression against the United States. However, Congress did not accept such a broad interpretation of the AUMF. Instead, if I may point you to the record on page 29, 29 of the record has the AUMF. And the AUMF specifically says that those who planned, authorized, committed, or aided attacks that occurred on September 11th. Here, this organization has not committed, aided, or planned attacks on terrorist organizations. And in fact, what's going on here is the majority of it is the American people's communications, not ISAC communications, that are being intercepted.
But isn't the AUMF a statute aimed at preventing conduct rather than using it after an attack?
Yes, Your Honor. The AUMF is used to prevent conduct. However, according to the AUMF, it's a limited scope. It's a very narrow statute that was intended. If Congress intended it to fight any war on terror, then they would have said that explicitly. But in this case, they chose to limit the scope of the president's power specifically through the text: planned, authorized, committed, or aided. Those.
Do you want the government to reveal at this point the use of the information?
Absolutely. I believe that it is the government's obligation to reveal at least to how effective this program is. Similar to the case in Clayman v. Obama, the District of Columbia ruled that because the government could not prove any evidence stating how effective the program was, and that program was a nullity. And
Counsel, isn't the similarity between ISAC and what happened in 9/11 very close? ISAC, in fact, is an offshoot of Al-Qaeda, according to the facts. It derives out of the Middle East. It derives out of the culture of what's going on in the Middle East. I mean, couldn't we say that the authorized use of force language squarely covers this?
No, I do not think that we can automatically say that it squarely covers this, Mr. Chief Justice.
I mean, you hanging your hat on the fact that ISAC didn't exist in its current form when that act was passed, is that your point?
No, Your Honor. I have 2 points to your question, Mr. Chief Justice Arenas, and that is that the petitioner makes the first argument that ISAC is not an organization that Congress sought to target because they are effectually different than Al-Qaeda at the time.
So even if they are different in some ways, are they different in a relevant way? I mean, if they have some connection to September 11th activity, which is they're also connected to Al-Qaeda, then shouldn't they be covered by this? Because in the alternative, it seems that your argument must be that this statute just is void. If anything that happened after September 11th isn't covered by it, then what's the point of having this statute? Is it your argument that it's void?
My argument is that the statute relates wholly, not wholly, but the statute, as enacted, it regards foreign intelligence, which the president has more of an authority to command such a program. However, here in the domestic context, the petitioner believes that it is not the president's power to order such a program. Specifically, if I may point the court to my second point, which is that Section 215 of the Patriot Act, which the government relies on to say that what they're collecting is constitutional. And in that instance, the petitioner argues that the Section 215 relevance requirement is not met here, specifically because the civil context of relevance is too broad in the context of metadata collection.
Well, shouldn't 215 be interpreted very broadly, especially in light of the fact that Congress has reauthorized it 7 years in a row?
Your Honor, you make a good point. Congress did reenact and reauthorize Section 215 7 times. However, their reauthorization of it cannot be implied from there that they implicitly accepted that construction because this order primarily dealing with confidential access to records. It is arguably that Congress did not have any knowledge, and those who did have knowledge in Congress were those on the intelligence committees, which is very few of the hundreds of members in Congress today.
So, if Lanza did not record this metadata in a sense in real time, let's assume it didn't do it. where does that metadata, does it still exist? Could it be obtained later from another source?
The metadata in this context, if it was not collected by the government, if I may clarify your question, Mr. Chief Justice, are you asking that if it's not collected
Let's assume that the Lanza program just didn't operate. They just didn't do it. They weren't collecting it as it was being created.
Okay.
Okay. All right. Now it's a year later, and the government now has some information of a certain individual they suspect may have had certain calls to certain telephone numbers or certain IP addresses, who's a suspect of some kind. And so now the government wants to look at the metadata. Is there any place they could go for it?
Well, what is distinguishable?
Where does it still exist somewhere? And if so, where?
The metadata may still exist in the data world.
In the what world?
Off in the data, I call it the data space, if I may, Your Honor. Off in the data space, and it may be accessible by the Glimpse, Glimpse authorities.
For instance, will Glimpse have this data?
Glimpse may possibly reserve this data, yes.
I mean, the data, so the government then could, depending what requirement they were subject to, could go to Glimpse to try to get the data?
In that instance, Your Honor, I believe that there's a distinction in that case, if I may. In that case, the government would be looking at a specific target, whereas here they're collecting the data from all users indiscriminately, continuously, without any effective keywords, any usernames who are identified as recruiters. And that's why that the petitioner argues that the relevance requirement in the civil context is an inappropriate way to assess relevance here.
Counsel.
Yes, Your Honor.
The billions of bits of information that Lanza has produced, is it looking at just what Lanza has produced, looking at any other information brought to bear? Is that information have any value to the government? Can they do anything with it?
The metadata can reveal a lot of information about a person.
How would they know?
You're looking at where a person was at what time, how many...
You have to identify a person. You have to bring other information to the government. If you just looked at the data itself, it's not worth anything to the government, is it? Just by itself.
Well,
you couldn't get anything out of it.
Just by itself, and even, well, to that point, Mr. Chief Justice, I would argue, the petitioner argues that that's exactly a good point. The government can't get anything, so this program is essentially ineffective.
So you're presuming that the government, once it has this data, will bring other data to bear, like a name, a date, a time, a telephone number, and then use that other information that it got from some other source to get metadata related to that person or that number or that IP address or something like that. But without that additional information brought to bear, the universe of data that Lanza gets isn't worth anything to anybody.
Well, Mr. Chief...
Just except as a storage device to keep it.
Well, Mr. Chief Justice, I would clarify, if I can, the significance of metadata. Metadata reveals the exact phone that was used, where it was used. It reveals so much information that if one...
What good is it? What good is it? So they have millions or thousands or tens of thousands of... Unless they have some other information that they can use to focus in at a particular time, a particular telephone number, a particular recipient, particularly IP address, they've got nothing. It's just a mass of data that has no meaning unless you bring to bear some other information that you can use to take this huge mass of data and narrow it down in some usable form.
Your Honor, if I may, this brings me to 2 points. First, the petitioner does contend that metadata is... This brings me to 2 points. The petitioner contends that metadata is important and it reveals a lot of information about a person. And the second point is that...
You know the person you're looking for. If you had it, there's just dealing with millions of calls and millions of text messages. And I mean, they could go thumbing through that stuff forever. You could have 1,000 people going over it and it wouldn't get you anything. Unless you had some narrowing information that you would develop from some other source and then at that point, use that other information to narrow down this great mass of information you have into something usable.
And thank you for that question, Your Honor. And that brings me to the
You're
second.
welcome.
And that brings me to the second point: is that even if this court finds that the metadata is not significant, we would argue, the petitioner would argue that that means that Order 41019 is wholly ineffective and should be a nullity. Because in this, Your Honor, I see my time is out. May I briefly conclude?
Let me ask you one more question.
Yes, Your Honor.
If we concluded, or somehow or other the proof showed, that this information would be available, let's just say from glimpse, even if there was no Lanza, wouldn't that help your position? Because you'd say, well, at least then we know the government couldn't secretly use it, without telling anybody, and they would have to go and justify, whether under 215 or under Fourth Amendment, to justify access to glimpses records of metadata. Would that help your position?
It would help our position, Mr. Chief Justice, and we believe that it is the government's burden in this case to prove that they're seeking a specific individual, such as the requirement and subpoena to subpoena documents. They're seeking a specific target. Here, there is no specific target, and the government has not proven that there's any target whatsoever. That's why that the petitioner asked this court to follow the relevance requirement followed in the American Civil Liberties Union versus Clapper case from the Second Circuit Court of Appeals. And in that one, they do a two-pronged test to determine relevance.
Clapper was putting on the GPS device on the car, wasn't it?
Clapper was a telephony metadata collection program that was ruled a nullity.
Oh, that was thinking of another.
Well, let me ask you this question. I just want to change the subject, go back to your relevancy argument under 215. But the AUMF, Congress gave the president power to use all necessary and appropriate, I guess the word is force, it may be different in the statute. Why isn't the collection of this information necessary and appropriate, even if I agree with your irrelevancy argument under 215?
Justice Slomski, this is not relevant because the government had alternatives before implementing. It is not a necessary and appropriate force. They had less intrusive ways to collect to actually look into the lives of those who are reasonably believed to be related to Isaac. First, they should have identified usernames, keywords, or common patterns, which is which is in Clapper the first prong to that relevance test. And then the second prong would be that the collection of metadata would not amass to an unnecessary amount of irrelevant material. And that's exactly what's going on here.
Every investigation has to start somewhere, and maybe they needed to get first the metadata in order to figure out what usernames they needed. I mean, isn't that a reasonable step? They're not asking for content yet. They're not asking yet for names, for other much more private information. If this is what they needed in order to begin to start collecting relevant data, why isn't it okay?
Well, because what the government is doing here, Justice Abraham, is they're switching the burden here. The government must first prove that what they're seeking is relevant, and then the authorized investigation may proceed. However, here the government is saying, give me an authorized investigation, and I'll show you that it's relevant. And that is contrary to Section 215.
So one more question before
Yes,
I think your time is long gone, but it's fled. But isn't in a sense, the root of your argument, the assumption that the government will not just collect this metadata, but will actually use it in connection with specific investigations without getting anybody's approval of any kind, whether under 215, under the Fourth Amendment, under inherent, they'll just do it. Isn't that really the basic premise of your argument?
Yes, Your Honor. What the government is doing here, if the government's position is correct, they will be permitted not only to collect metadata from Glimpse, but all social media applications. Not be able to collect electronic communications under Section 215, but they'll be able to do it under every run-of-the-mill subpoena statute. And most importantly, not just in investigations into terrorism, but into every investigation involving more than one person. Such an intrusion into the lives of Americans is not the American way, and that is not what Congress intended. Thank you for your time.
Thank you.
Thank you.
Yes, you may. Ms. Mack, would you like to reserve some time for rebuttal?
No, thank you.
No.
No.
Okay, you may proceed.
Good afternoon, Chief Justice Irenas, Justices Abraham, Slomsky, and Soto. May it please the Court. My name is Molly Mock, and I, along with my co-counsel, represent Alexa Benares, the petitioner on this appeal. Your Honors, this case is about the government grossly overstepping its authority and violating the fundamental rights of millions of Americans, including Ms. Benares, who are just trying to communicate in a free country.
How do you translate your privacy rights into this mega data?
I'm sorry, could you clarify your question?
Yes. Do you have an issue of privacy in the information and the mega data? Do you? And why? It's not content. We're not talking about content here.
Ms. Benares does have a reasonable expectation of privacy here in the metadata because the collection of metadata and looking at it in the aggregate can paint a mosaic of what a person does daily, of their religious beliefs, of where they eat, and who they're talking to. The metadata collects the location from where the message was sent, to where the message was sent, and the personal phone numbers of both the sender and the receiver.
Counselor, when people use telephones, don't they presume that the phone company keeps track of the calls they made and where they were made from? Because it shows up in the bill. That's how bills are constructed. And why isn't it, no one really believes that they have a privacy interest in that information. Privacy concerns with phone calls would be with the content of the call. And likewise with Glimpse, why would any individual have any reasonable expectation that the numbers that they're calling from and calling to would be kept private, particularly in light of the fact that Glimpse offers a lot of privacy options to its users, but none of them relate to metadata. It all relates to content. So how could she have a reasonable expectation of privacy in what we all know companies use all the time and maintain and rely on that information and don't keep private?
Justice Abraham, if I may address your question in a few points. First, the security features of Glimpse make this different from a telephone company. It may be true that telephone companies, and it is widely known and accepted that telephone companies keep these phone number records, but Glimpse advertises itself as a private, secure platform to communicate on. And Ms. Benares has implicated all of the security features possible in order to protect that information.
But did any of them relate to metadata?
No, Your Honor, there were no security features available for metadata, but Ms. Benares reasonably took all of
that conclusion. I mean, there's no possible security features available for metadata? You know that for a fact?
It's not indicated in the record, Your Honor, but if I may point to this court.
Either way, it's not indicated in the record.
The security features of Glimpse are a notification for a screenshot. There are ways you can separate people into groups so you don't send a message to somebody you don't want to. And you can send messages personally to people and not post it to the public. And that's what makes it different here. And in Kylo versus...
also make some things public, available to the public under Glimpse as well.
That is true, Your Honor, with the stories. But here we're talking about the message transmissions for specific messages that the government is collecting and looking at. Ms. Benares can choose to post something to the public, but she's also choosing to keep certain things private. And in Kylo versus United States, this court found in 2001 that the government conducted an unlawful search in violation of the Fourth Amendment when they used thermal imaging technology to look into a suspect's house to register heat signatures.
Well, that's invading the curtilage of a house. That's actually getting something out of a home, which is probably the number one reason for the Fourth Amendment, to protect people in the privacy of their homes. Isn't this a little different when you put this information out on the airwaves, so to speak, over electronic lines? Isn't there less of an expectation that the information is being kept confidential?
There isn't a less of an expectation here, Your Honor, because in this phone-centric society, it is ingrained in our people to use these social media apps, and they carry around their cell phones everywhere they go. The information that's kept on their cell phones sent out from their cell phones, and also the metadata generated when doing such actions, it can be equated to a home in this situation. And within Kylo, this court did find that even though the suspect did not have any way to contain the heat in the house, just like here, Ms. Benaros does not have a security feature to contain her metadata from going to glimpse, that they had a reasonable expectation of privacy.
Yeah, but answer Judge Klomsky's point. I mean, his point is that every man's home is a castle. That was the kind of,
Yes.
And homes get the highest level of protection from unreasonable searches and seizures. This is just something way different than that was this question. I'd like to hear what your answer to that is.
In technological advancements in this day and age and how society uses technology, in particular cell phones and social media apps, they take it when they leave their home. They take it everywhere they go. And Ms. Benaros in particular has all of their information about themselves personally in the cell phone and what they do with that cell phone. And
that argument rings true for content. And the court has said that, what people used to keep in their private safes or other things in their home that were very private now may be on their cell phone, that it's the repository of a lot of private information. But I don't think the court has ever said that about metadata. And I think the distinction between content and metadata is really important here. That the content of our messages, yes, and we may have very private information there. But the question was about metadata. And isn't there a distinction between that and what we keep in our homes? And the very high degree of privacy and protection that we have in our homes. Why is that accorded to metadata? Most people might not know they even have metadata.
Yes, Your Honor, that may be true, but metadata can tell a lot about a person. And in this case,
Can't subscriber telephone information also tell a lot about a person?
I'm sorry, Your Honor, could you repeat?
Subscriber information that is obtained from the telephone company by a court order would reveal the time a call was made, how long the call occurred,
Yes, Your Honor.
et cetera.
I'm sorry.
From where and to whom? Isn't that the same?
Yes, Your Honor, but the key here is that the government did not get a court order. And they're claiming that this is not a search under the Fourth Amendment. And the petitioner maintains that this is a search under the Fourth Amendment and violates the rights of not just Ms. Benaros, but millions of Americans who are using Glimpse for their secure platform reasons.
Would it matter, would your argument be different if the government secured metadata on, say, 1% of the total population as opposed to 100% of the total population? Does the amount of metadata make a difference?
No, Your Honor. It's still an invasion of privacy under the Fourth Amendment. And society deems this privacy expectation as reasonable. It found in United States versus Graham out of the Fourth Circuit in 2015, the court discussed that this phone-centric society expects more privacy in using their social media apps, not less privacy.
Well, isn't it common knowledge that the metadata is already collected by many internet companies in order to determine what your favorites are in advertising and sending you information?
Yes, that's true, Your Honor, and it speaks to the point that metadata reveals a lot of information about individuals. And in this case, Glimpse is advertised as a secure platform for private messages.
Right, again, but you're not distinguishing between content and metadata. Alexa Bonaros was aware that she had some control over the content and to keep it private. She was never told she had any control over the metadata. She never exercised control over the metadata. It's reasonable to assume that she didn't believe she had any control over the metadata. How do you counter that?
Your Honor, the Glimpse secure platform, the more security features that you implement on whether it's Glimpse or any app, but in particular Glimpse, the users have a more and more of an expectation of the privacy in all of their information. And
well, that's just giving a conclusion. I mean, that's not an argument.
Justice Sotomayor in United States versus Jones, decided by this court in 2012, recognized that metadata can reveal a wide variety of information about a person, including personal relationships, religious affiliations.
Exactly. How does it reveal personal relationships?
If I send a Glimpse message to my co-counsel, then if the government collects that information, even just the fact that my number sent my co-counsel's number a message, it shows that I have a personal relationship with my co-counsel.
So everybody you send something to, the government, we can conclude that there's a personal relationship because you called somebody up?
But the government, not necessarily, Your Honor, but in this case, the government is collecting all of the glimpses for the past 16 months, indiscriminately and continuously invading the privacy. And it shows over that period of time, it can show the relationships between people. And it can even show where you go to church. If you send a Glimpse metadata message from the church you go to every Sunday, or whatever respective.
So in other words, I mean, I understand your argument if you're saying that metadata, if it's pervasive and prolonged over a long period of time, can become equal to content. Because one day of calling someone might not reveal anything, but over the course of 8 months, if you contacted that person 8 times a day, suddenly we have content about your relationship, or at least a little bit, something approaching content. So is there anything that the government could do, or this court could do, that could correct that? That the government, are there any limitations here that would limit this collection of metadata so that it's just metadata and doesn't approach content? Or is, for example, if the government only collected metadata for a week, would your argument be the same, or do you think that might be permissible?
I think that it would depend on the particularization of the government's investigation. And in Smith versus Maryland, they did have a targeted investigation, or Smith versus Maryland, that the court did decide they had a particularized investigation, but here there isn't. Here they are collecting metadata from millions of Americans. And
are you assuming that the government will not just collect this data, but will actually make use of it in various investigations that they are engaged in without getting anyone's permission for that? No search warrant, no 215 order, that they'll just start using. It's one thing to have it, but to use it in a particular investigation, they have to bring further information to the table, if you will. Are you assuming the government's going to do that without any permission of any kind? Is that the basic assumption of your argument?
Not necessarily, Your Honor, because even the fact that the government is collecting this large amount of metadata.
But if they collect it but don't look at it or try to analyze it or use it in any particular investigation, they just collect it in one spot. But that if they want to use it, let's assume they go for a search warrant. Would that be okay? Let's assume the government announced, we're going to continue to collect it, but we're not going to actually access it to do studies or things unless we get a search warrant. Would that be okay?
No, Your Honor, because that means we also take the government at their word, and in the fact pattern.
So you don't believe the government. You believe the government's lying to you and that they really are going to use it without a search. Even if they announce, I'm going to get a search warrant every time we want to access this information. Well, you're saying we can't trust them. They're going to go out and use this information anyhow, right? Is that what your argument is?
No, Your Honor. They should get a search warrant before they collect.
Well, let me try to ask the question another way. Would you have an objection, a Fourth Amendment objection, or some constitutional objection, if the government simply said, we are only seeking this information now to preserve evidence? If we actually need to use it at some later point, we will go before the court and ask for a search warrant. Because of the possibility that Glimpse may lose these records or Glimpse may no longer exist when we need it, we're just getting this information now in an effort to preserve the records but not to use it. If we feel we have enough to get a warrant, we'll go before the court if we're going to use it. Would that be okay? Do you have an objection to that? If the government was telling the truth, just assume good faith.
Yes, Your Honor.
Assume.
There is an objection to that because there is no basis to collect this metadata in the first place then.
No, to preserve it. Her question is, you're doing it because if Glimpse goes out of business or a hurricane destroys their servers, this way, that data will not be lost. Not that the government will necessarily use it without a search warrant, but it just won't be lost. It'll still be there.
I'm sorry. I see I ran out of time. May I?
You may answer that question. I was very generous with your co-counsel.
Yes, Your Honor.
And I got to be generous to them, too.
The government's collection and even just maintaining this, all of these glimpses is severely infringing on the fundamental rights of the individuals. And for this court to rule in favor of the government, it would severely erode the Fourth Amendment rights. Thank you.
Thank you.
Okay, thank you very much. Okay. Mr. Mitz? You going to save any time?
No, thank you, Your Honor.
Oh, you don't get rebuttal, right? Tough on you. Go ahead.
Chief Justice, Your Honors, opposing counsel, my name is Joshua Mitz, and I, along with my co-counsel, will be representing the United States of America. We ask this court to uphold the lower court's decision when they allowed for the bulk collection of metadata for the following two reasons. The first is it is authorized under two acts, both the authorization for the use of the armed forces and Section 215 of the Patriot Act passed by Congress, and by the President's enumerated powers under Article 2 of the Constitution. Your Honors,
let me ask you just one question. Are you assuming, because I asked this question also, both of these people, are you assuming that the government will not only collect this data through the Lanza program, but will also use it in connection with specific investigations it is conducting of one kind or another? Not just that it'll keep it somewhere, but they'll actually bring to bear other information which, together with the data, might help them in some way.
He is the government.
Huh?
He is the government.
Well, that's what I'm asking him. He is the government. I want to ask him if that's his assumption.
So, yes, Your Honors. Going to Section 215 of the Patriot Act, in order to have a court order...
Are you assuming that the government, without any other kind of permission, not using 215, not using the Fourth Amendment, will not only collect the data, but will make use of it in conducting specific investigations?
Only the specific...
Without any further approval by anybody, other than whatever existing legislation there is, but without any specific approval, again, by a 215 order or a warrant, a search warrant.
So, no, Your Honor, the government does not intend to use the information outside of what it is authorized to do.
No.
The information,
right?
You're not just going to hold the information. Anytime you feel it's necessary to access it in order to use it as part of some investigation, you use it without a court order or without getting a search warrant. That's your intent in gathering the information, is it not?
He's asking my question by answering it.
Right. But that's not the assumption, Your Honor. The government doesn't intend to utilize the information without going further, without getting permission. It doesn't have the intention to collect any more information, to utilize any more information than it is already allowed to do.
And why didn't you go back to Congress and ask Congress for permission to just collect it but not use it and tell Congress you won't use it without further authorization? Congress could have written a very different law than the one they've written in these two instances.
Because, Your Honor, Section 215 of the Patriot Act does allow him to collect the information for an investigation, especially after he obtains an order from the Foreign Intelligence Surveillance Court, which he has done here. The NSA specifically has this order and is compelling glimpse to give them the information through that order.
Where specifically does it give the president authorization? Where does Congress specifically say so?
So under Section 215 of the Patriot Act, it specifically allows the government, the president, to collect information relevant to either international information or to protect against international terrorism.
Is it your position that this order that you're referring to allows the government not only to collect with the Lanza program all this information, but to use that information in connection with specific investigations it's conducting?
No. Yes, Your Honor, with Section 215's approval. That's the only reason.
Your position, they don't need, they can, not only then, Justice Slomsky is right. The government's position is not only can it collect all this information, but if it feels it needs to use it, can go ahead and use it without any further order or any further search warrant or any further permission of any kind.
The utilization of the information is to, well, they're conducting relevant searches in order to root out terrorism. They're trying to protect our country from international terrorism, which is allowed under both Section 215.
Your adversary argued that this wasn't international terrorism, that this was simply domestic, because these were American teenagers who committed acts of violence on American soil. So how do you argue and show support for the fact that these American teenagers and what they did, and the people who use glimpse, all of which, as far as we know, are also Americans, represent international terrorism?
Because, Your Honor, in the case below, Bananas versus the United States, it specifically stated that the last act that actually happened in this city was orchestrated through ISIC, and before that there was an attempt on a high school in Pennsylvania, also orchestrated through ISIC.
What about the other two supposed acts of violence or terrorism? Were they connected to ISIC? Is there any evidence of that?
There's not any evidence either way. However, they did not occur until after ISIC's formation, until after ISIC had 30,000 members in its organization, and until they started attacking everyone in the world. They've already taken over 1,000 lives, and there shouldn't be that much.
How do we know these aren't individual acts by individual American teenagers who, yes, might have been influenced by things they read in the newspaper that are international, but how do we know that they are connected to some sort of an international organization in a way that we can call this international terrorism?
Simply because it was orchestrated through members of ISIC, as per the case below. It's members of ISIC who are utilizing this platform in order to communicate with American teenagers, in order to communicate with anyone who would be willing to conduct these terrorist attacks.
So how many teenagers were involved in these two acts that we know had some connection to ISIC? So I'm not asking about all four, because we don't know if the other two were connected at all. How many American teenagers were involved in that?
There were at least 3 in the Pennsylvania bombing, and I'm not sure that the record specifically states how many in New York, but it was over 3, and they were shouting "Death to America, ISIC lives" when they were caught.
So fewer than 10 American teenagers is sufficient to justify the president gathering information from how many users of Glimpse? How many million?
25 million, Your Honor.
25 million people's privacy gets violated because of 5 or 6 teenagers? That's international terrorism?
Yes, it
You've
is.
heard about the undeveloped teenage brain, haven't you?
Let me ask you this question. You're relying upon Section 215 of the Patriot Act, and from what I'm reading, it permits the government to collect the metadata if it's relevant to an authorized investigation. What's the relevancy here? And first of all, what's the authorized investigation? And secondly, what's the relevancy here of collecting millions of pieces of data to whatever that authorized investigation is? I mean, these are the prerequisites in the statute.
So to answer both of your points, Your Honor, the first is the relevancy is any information related to acts of international terrorism coming from ISIC. And the relevancy comes from the fact that it was this court that decided Oppenheimer funds versus Sanders, and it said that the government may conduct an investigation just for either the assurance that a law is not being broken, or if they believe that the law is being broken. This case was upholding a case, Oklahoma Press Publishing Company versus Walling in 1946, which also said that just because there's a large-scale investigation, it doesn't bring any unconstitutional implications if there is at least a chance that one document will be relevant. This is what's happening right now. There is a chance that one document will be relevant. It is relevant to the search at bar.
What definition of relevance are you using? Are you using the one in the Federal Rules of Evidence?
The relevance that we're using comes from, it was the case American Civil Liberties Union versus Clapper in 2015. They applied a relevance standard coming out of Oppenheimer, which is for grand jury subpoenas. And that standard is very...
Why is that the right one?
It's the right one because if that case will allow the relevance of information for something civil, if something is dealing with the lives of Americans, if it's dealing with protecting this country, which the president is authorized to do, then the relevance should be broad, because otherwise there's a chance that this country won't be protected.
So relevance or could lead to relevant information. Is that what you're saying? Are we turning this into a fishing expedition? Are we exploring taking everyone's rights just because there might be a little tiny bit of relevant information that could be gleaned?
Well, preventive detention would might help save American lives. We'll just round up people without any real proof or warrant, put them in jail. If we have some suspicion, they may be subject them to waterboarding or extensive questioning. That would help. That would definitely make us safer, wouldn't it?
Isn't it? The problem is, aren't you talking about the blank check that your adversary started his argument with, and there are just insufficient limits on what the president can do?
So to answer all of your points, first, and I guess this also goes in with Justice Abraham's point about a blank check and a fishing expedition. This isn't particularly just a fishing expedition. This isn't a blank check. The court held in ACLU versus Clapper that because of the broad spectrum, all cell phone users, the government couldn't collect all the telephony metadata. But here, this is just one application. It's only glimpse. It's very narrow in the sense that it can be. This is what the government needs to do in a narrow scope. This is as narrow as it can be. And this is what it needs to protect this nation. Under the authorization for the use of the armed forces, actually, the United States, and this is addressing your point, Chief Justice Arenas, the United States the court interpreted this statute in Hamdi versus Rumsfeld in 2001. And it said that in the face of an American citizen who declared war on the United States, that the government was allowed to use all necessary and appropriate force, which was detaining against his will.
Isn't the concept of protecting the United States a very slippery slope? I mean, every dictatorial government in the world uses that as an excuse. We're throwing people in jail, we're arresting with endless detentions, and we're doing this and that. We're doing it to protect the country. And that's been used by every dictator everywhere in the world.
Doesn't the Constitution require some more concrete limits? What limits are there?
So, under Article 2 of the Constitution, the President has the power to Your Honors, the President has the power to be both the Commander-in-Chief of the Armed Forces. He also has the duty under the Take Care Clause to faithfully carry out the wills of Congress and to make sure that the Constitution is upheld.
Does the Commander-in-Chief power apply when war hasn't been declared?
So, Your Honor, the war might not have been petitionally declared. However, both a senior member of Congress and petitioners themselves equate this to wartime. The senior member of Congress...
Can you answer my question? Does the power apply when war hasn't been declared?
The power applies for the use of the armed forces regardless of whether there is a war. It's the scope that is different depending on when there is a war.
Well, you agree that all three powers, the three different clauses, as well as any direct power given by Article 2 of the Constitution, are all subject to other constitutional limitations. You would agree to that?
Yes, Your Honor. However, in order for the President to uphold the Constitution, Number one, there must be American lives to uphold the Constitution for. And second, he's not violating any constitutional rights by protecting these citizens. The most he is doing is conducting an authorized investigation, which he is allowed to do by both Congress and by his powers. What the president is doing is simply trying to uphold the Constitution by making sure there are lives and that everyone's rights are being upheld.
So you look at the collection of data, the metadata, through the Lanza program is more than just preserving it. You look at it as actually intended to be used in ongoing investigations without any further approval by a court of any kind.
If the investigation gets to the point where it requires a warrant, the government will get a warrant, which is evident by the fact that he's already gotten a fiscal order every time that he's had to in the 90 days. And further, it's presumed under Forest Grove District versus TA in 2009, decided by this court, that if Congress reenacts a statute and it doesn't make any changes to the statute, it's presumed that Congress understands how the president is interpreting this statute. This not only has it said in the case below that the president is having meetings with Congress, it is showing Congress what it is doing, but the president is interpreting the statute as he has been for the past 7 years. And if Congress decides that they don't agree with that, it's coming up in December for Congress to reauthorize the statute, and they can make changes then. It's only 3 months away. We would ask that if the court does find that this is even remotely unauthorized, that it was at least use judiciary restraint and wait for Congress to take a look at this matter one more time. Ultimately, Your Honors, this isn't an issue in which the president is acting outside of his broad scope. This isn't outside of his narrow scope. This is just an issue in which Congress isn't allowing him to do anything. This isn't an issue in which he's not acting within his powers. The Constitution isn't a suicide pact, and we shouldn't wait for any more deaths to happen before we allow the president to do what he's allowed to do. Thank you, Your Honors.
Thank you.
Thank you.
Thank you. Mr. Benzenberg?
Good afternoon, Your Honors. As mentioned, my name is Eric Benzenberg, and I'm here to represent the United States of America with my co-counsel. Less than 15 years ago, the attack on 9/11 occurred here in the United States, the most deadly attack since the Pearl Harbor attacks that occurred during World War II. Shortly thereafter, 2014, once again, the United States of America, specifically here in New York, was attacked by a terrorist organization identified as ISIC. The United States government is here reacting to those terrorist attacks to prevent and do what is necessary to prevent additional attacks and unnecessary loss of American lives here on the homeland.
Are you comparing what happened from a couple of American teenagers this year in New York to what happened to the World Trade Center in 2001?
Justice Abraham, terrorists have no age that determines how much of an impact they can have on an American's life. They all have the capability to take lives in a senseless manner, whether they're older flying planes into buildings or building homemade bombs and activating them at parades.
That's true. The question is, should this court be guided by fear every time a few teenagers commit a prank that 2001 is about to happen again? Justice
Abraham, there's been conclusive evidence addressing that ISIC did coordinate the attacks in New York here, those teenagers who made that homemade bomb and activated here in New York at that parade. It's been shown that, once again, the ISIC terrorist organization did its recruiting and coordination efforts through the Glimpse social media application. To determine whether or not a search, like the petitioners have accused us of here, has occurred, the standard that we used was first established under United States versus Katz. The two-pronged factors established under that test first address that the individual in question has a subjective expectation of privacy. The second prong of that test evaluates the objective societal expectation of privacy. Here we contend that neither Ms. Bonaros nor society has a reasonable expectation of privacy.
But didn't the petitioner enable on Glimpse all of the privacy aspects that were afforded?
Yes, Your Honor, and like Justice Soto had mentioned earlier, those privacy features had only addressed content that was transmitted through the Glimpse social media application. They did not address...
But she took advantage of every every opportunity available to her to request security or privacy, doesn't that indicate that she had a subjective interest in keeping her messages private?
Yes, the content of her messages.
Well, since she was so concerned with the content being private, can't we fairly assume that she also wanted her metadata kept private?
Your Honor, in U.S. v. Miller, the court there held that transactional data information related to an individual's bank account could not have a reasonable expectation of privacy in it. Comparable here to the transactional data with a bank account, in Ms. Bonaros' case, the metadata, the background information that occurs when she sends a message over Glimpse, the time, who she may be sending it to, the locations of the recipient and the sender. Those information are identical to the transactional information in a bank account.
I'm sorry. Recent surveys in America show differently, that only about a little more than half of the population, and it was a very small pool, think that they don't have privacy rights. How can that be equated to the United States of America, the entire country at large?
There are two issues that I'd like to address with the Munoz report. First, the sample size was taken over an approximate 10-year period. However, the size of the sample equates to less than 3% of the American population, creating a very, very small sample that actually could be judged for the data that was provided. Secondly, the question that was asked addressed whether or not electronic communications were under government surveillance. Here, there's no distinction between whether that electronic communication addresses content or, once again, the background metadata that the petitioners here are challenging.
Is it your position?
What would the petitioner have to do in order to invoke privacy rights in the age of the Internet? Do they have to write a letter to their server saying, please do not release my metadata, I want it to remain private, or any other, or a glimpse? I mean, what's the burden on a person today in this day and age?
Your Honor, in today's technologically advanced world, specifically with smartphones, which essentially put a computer in every individual's pocket, you're fully aware when you first buy that smartphone that your personal information, specifically where you might be, is...
You're saying there is no privacy.
There's no reasonable expectation.
Giving up all your privacy by buying a smartphone.
No, in Smith v. Maryland, as you had mentioned earlier, Your Honor, is equivalent to that kind of expectation of privacy, that by choosing to use a smartphone and more so the social media application Glimpse, you've relinquished your expectation in privacy because you're fully aware.
The Supreme Court just held that you need a search warrant in order to access information on a smartphone.
Even if you seize that smartphone incident to a lawful arrest,
right?
That might be, the seizing of it might be lawful, but going into it to get out the data is not, doesn't follow that just because you lawfully seized the phone, you can go into it to pull out the data. You're aware of that?
Yes, Your Honor. In the case, I believe the central issue there was that the police, after making a lawful arrest, were obtaining the content of the phone, not the background metadata that the government...
Let me ask you this. If you apply for just a routine house mortgage, you are going to give the bank financial information, I mean, tons of personal information about yourself, your family, your finances, whatever else, properties you own, an endless amount of data. Take it from me, I went through it. Do you think I've lost an interest? Do you think by giving the bank, by applying for a mortgage and giving them all that information, I've basically said to the world, anybody can have my stuff. Just go out and, I don't care anymore.
Well, once again...
Do you think that was my intent when I gave that information?
I think the pivotal issue there with that kind of an example, Your Honor, is the physical element of applying for a mortgage and a home. In contrast to U.S. v. Jones, Riley v. California, or Bond v. the United States, all of those courts found searches specifically because of the physical intrusion on the individual. Here, there is no physical intrusion. Government agents of the NSA are not running up to Americans that they identify as glimpse users, asking them to relinquish their phones.
So in other words, because of all the advances in technology, they don't have to physically go into your house. They can just get the information, get the data from servers. You're saying then it's not a violation of privacy. And in other words, it seems to me that your argument is the way society's involvement with technology has evolved, we've lost any expectation of privacy, and that constitutional protection is now gone. If we engage in the level of technology that has become the norm, then there's no more privacy, and we can all accept that. And I think the courts have said otherwise, haven't they? Haven't they said that even if technology gets more advanced, it doesn't mean that we give up our expectation of privacy? We have to carve it out and figure out how it applies to this new technology, but we're not ready to give it up. Isn't that something that's important to American society and values and embedded in the Constitution, no matter what level of technology we communicate with?
Your Honor, there's a voluntary relinquishing of the personal information when you choose to not only use a
And that
smartphone.
voluntary relinquishing, your argument is anytime you engage with social media, smartphones, and the internet, you're giving up your right to privacy?
Once again, in Smith v. Maryland, Your Honor, by choosing to be a user of a telephone, you're now relinquishing that possibility that the telephone company
So the
might...
answer to my question is yes.
Yes, Your Honor. By choosing to use the Glimpse social media application, you have, as an individual, as a participating user, you have lost your expectation, and a reasonable expectation in privacy.
So in other words, if they were going to be concerned with consumer rights, they would put on the front of their package, if you use this, you're giving up your constitutional right to privacy.
Glimpse communicated to all users that the expectation in privacy and that they're, as a brand, their promise was the privacy in the content. They did not make any promises about the metadata.
Let me ask this question. In the telephone context, a person gets a bill from the telephone company. In many cases, it'll give the information that the government wants. So the person knows that by using the telephone, that this information, it knows the kind of information that's going to be made available if the government ever subpoenas it or gets a court order to, otherwise gets a court order to get the information. That isn't true in metadata, though. What is there about metadata that puts me or anyone else on notice that as to the kind of information the government's going to seek?
Your Honor, I think that equates once again to U.S. v. Miller with the banking transaction information, that when you do go to the supermarket, you make an electronic online purchase, you're not visibly seeing there the transactional background information that occurs at your online banking level, the transaction between the processing information between the potential retailer and you as the individual consumer. Once again, a necessary part of sending these transmissions is that they will be sent over Glimpse, and they will record what time you will be sending them, who you'll be addressing them to, whether it's an individual or a particular group you've chosen.
But how many people actually know what metadata is? I mean, everybody knows the information that you get on a phone bill, but how many people know what metadata is? You don't get a bill about metadata.
Well, Your Honor, the recent events have kind of brought to light how important and how much information actually goes on in the background, the metadata that's ongoing, specifically with events as this here at hand, and Edward Snowden also with the Verizon cell phone record the cell phone metadata records of individual users on the Verizon carrier. In addition to that, a failure to find a reasonable expectation of privacy of the individual is not fatal to this test. The determinative factor here under the CATS test is a reasonable expectation of society in that privacy. Here we believe that there is no reasonable expectation of society in the privacy of individuals' Glimpse users' metadata. Once again, that would be followed up by the fact that the terms and conditions that every individual who is using the Glimpse social media application agrees to when they sign up for that application in the very first place, that they're given notice of the fact that as a user of that application, there's a list of information that could be relinquished, analogous to Smith versus Maryland with their user information.
Is that on the record? Where in the record is that every user of Glimpse agrees to give up the privacy of their metadata?
It's nowhere in the record, Your Honor, but once again, she did sign up for a social media application that required a username, a password, and she did voluntarily also download this application. It wasn't something that came on her phone.
In order to use the social media, you have to have a username and a password. But is your argument that every time you make up a username and a password, you're understanding that you're relinquishing your right to privacy of your metadata? Is that your argument?
Every time you sign up for anything, Your Honor, a terms and condition is waived in your face upon signing up. And at that point, before your sign up is finally processed, you have the right to, at that point, agree to the terms and conditions or reject them and not sign up for the application.
Who reads that?
Your Honor, it isn't the government's responsibility to walk every potential user of Glimpse or any application or anything for that matter that terms and conditions come with to let them know that you should probably read this or look into this and make sure you're aware of what you're relinquishing at that
But
point.
even if you read it, is your argument that the only way to have a right to privacy in this society is to be a recluse who lives out in the woods somewhere, doesn't use telephones, doesn't use computers, and doesn't use social media? And then, in other words,
That's my wife.
You have your privacy, but that's all. You don't have anything else. You don't have society. You don't have relationships with other people. But that's the only way. Is that your argument? That's how you can maintain your right to privacy?
Your Honor, with Glimpse, it's once again, it's something for personal benefit and use. It's not something that's necessary to society. If petitioners have maybe been arguing about the email, the government surveilling emails, something a little bit more necessary to life in today's age where regular physical mail is sent back and forth, that's a possibility. But here we're discussing an application that's more for personal use and communication. It's not something that's necessary to an individual to function and carry on daily life within society. I'd like to close by addressing the fact that if this court finds that Executive Order 4109, the Lanza program, is found unconstitutional, there's a very strong possibility that it opens the floodgates for additional ISIC attacks, other terrorist organizations be orchestrated through the Glimpse social media application because of the notoriety that the ruling would get. In fear of that, we want the court to make sure, in addition to the American public, how important this program is to make sure that these kind of attacks do not continue to happen on American soil and that the government is doing everything it can to respect the rights of individuals while at the same time keeping them safe here in the United States of America.
The argument often used as a justification for unconstitutional conduct. You know, if we don't do this, there'll be a floodgate of crime, of attacks. Isn't that the last refuge of scoundrels? Not that you're a scoundrel. The floodgate argument?
Thank you, Chief Justice. For the benefit of the doubt.
What are you thanking him for?
May I respond quickly? Thank you.
Yes. You want you to respond.
Petitioners brought to attention that the prolonged and pervasive element here is what may constitute the search, the arbitrary element of the search. However, there are 25 million users of Glimpse. There are over 300 million Americans. This is a representation of less than 10% of the population. The government's actions here are just not aimlessly surveilling every single American individual. We're specifically targeting just Glimpse users because concrete evidence has been shown that ISIC coordinated terrorist attacks that happened in this country on our soil through Glimpse.
One last question. There is firm evidence out there, is there not, that some of these attacks that are taking place domestically have been planned with the use of Glimpse?
Yes, Your Honor. The most recent attack here in New York at that Macy's parade in 2014, it's confirmed in the record on page 1010, I believe, that the attack was coordinated through Glimpse.
Counsel, one more question.
Surely.
Could Congress pass a law saying that no organization can erase content for a period of 5 years after it's created, so long as the law makes clear that that doesn't give the government access to the information? They would still have to go through whatever the law requires, but that it had to be preserved for 5 years.
Your Honor.
So that Glimpse couldn't operate at all the way it operates because the government would insist that the content, let alone the metadata, be preserved for 5 years.
If in response to this court's ruling on this case, the Congress feels the need to pass a law addressing that issue, then that's Congress's responsibility to do so.
No, but do you think such a law would be constitutional?
It's not something necessarily at issue here. At issue is the current surveillance of Glimpse metadata.
Okay.
Thank you.
Thank you.
Thank you. You were the only one. You got 1 minute. You got to pack it in there.
In this rebuttal, I would address 3 points that respondents made. First, with respect to executive authority. The respondents incorrectly rely on Hamdi, stating that because there's a war on terror, similar to the war in Hamdi, that the president has executive authority. However, here, there is no war on terror. Specifically in Hamdi, the justices declined to accept that there was a global war on terrorism. And specifically in the facts at issue here, there is no active war, whereas in Hamdi, there was an active war in Afghanistan at that time. My second point is that Section 215, Congress cannot authorize something that they have no knowledge of pursuant to demerits, a decision by this court. And finally, Justice O'Connor in Hamdi, if I may quote, "It is during our most challenging and uncertain moments that our nation's commitment to our fundamental rights, like the Fourth Amendment, is severely tested." While the President and Congress do not need to address the horrific situation, while the President do need to address the horrific situation, if I may finish, conclude this last point. Thank you. They must do it within the confines of the Constitution and our fundamental rights. Otherwise, our fundamental rights will be subject to military deference and this ongoing and unforeseeable end to terror. And that cannot stand. Every citizen does not hold life, liberty, and property at the will and pleasure of the President. Thank you.
Thank you very much. If there's nothing further, the court stands adjourned, and we will be back. That's not, I don't know if that's good news or bad news, but we will be back. My getting up is a thing of beauty and a joy forever. Everyone, please be seated. Before I ask the individual justices to give their comments, I want to announce who the best oralist was and the best team was. And let me start by saying it was a very high-quality argument by everybody. I think we were all impressed with how you handled things. It was a very difficult fact pattern. I think even maybe more difficult than some. I've done 6 or 7, I think now, or something like that. And this was a particularly difficult fact pattern. There were some ambiguities. There were technical issues. And, of course, an abundance of legal issues that took a great deal of skill to handle. And I congratulate all 4 participants for doing a great job. We have voted that Mr. Ronald Cosme was the best oralist. And again, congratulations, Mr. Cosme. You're welcome to argue in my court anytime you want.
Thank you. Thank you.
Okay. But you all are welcome to argue in my court. We also had to pick the best team as a team. As the best team, we have selected, awarded that honor to Joshua, Mitz, and Eric, I hope I pronounced this right, Benzenberg. Now, starting at my far left, I'm going to give each of the judges a chance to make their comments on anything they saw today, or for that matter, life in general.
Well, I'd like to first address myself to Ronald Cosme. You are so smart. I was amazed. I think we all were amazed at your grasp of the law and your understanding of the facts, and how you were able to relate our questions to specific cases and answer them and keep your composure. I know that was very difficult with all the questions you were getting, but you didn't miss a beat. You were wonderful. Molly, it's just that you came after him. But I like the way you stood up. I like the way that you weren't really frazzled, that you challenged us and you answered our questions, and I thought you were very good too. Thank you. Joshua, I liked you a lot, Joshua. The only thing I didn't like is that I felt that you could have spoken up a little bit more. You know, there was a little time where I thought maybe I couldn't hear you, and I really wanted to, because you were on point. I liked your arguments, and I wanted really to understand what you were saying, so I wanted you to be a little bit more forceful in the future. Eric, you blew me away too. I like your style. You're very professional. You stand up there. You not only talk to us, but you listen to us. And you were able to talk to us individually about what our arguments are. And that memory really impressed me. So I think you guys, all of you, are going to have a great future. Thank you very much. Thank you.
There's not much left to be said here. The vote on the team was very close, and you've all learned about proof by preponderance of the evidence, and what we tell a jury is it just takes a grain of sand to tilt the scale that much, and when it does, that side has proven their case by preponderance of the evidence. That's how I feel how close both teams were in terms of presentation and knowledge of the law, and just performing in a way that overcame the jitters that each of you had standing before the judges of this panel. The presentations were very pointed. I like that. I think that in some instances you've got to do a better job in answering the question. You got to listen to the question that the judge is asking. Whenever you appear for oral argument, you can spend hours and hours preparing, and yet you're confronted with that question or two that you've never considered. I'm sure there are a lot of questions here that you never considered with all the preparation that you've had. And how you deal with that is somewhat of an art. I think all of you handled it well. I think there can always be improvement. It comes with experience. The more you engage in oral argument, the more experienced you'll become. And the more you'll be able to handle the unknown, which is what you really worry about when you go to oral argument. But everyone, I think, was excellent. The judge here has given excellent comments about everyone's performance, and I echo what she has said, and I know you're all going to have great careers as advocates, and you can all also argue in my court after you pass the bar.
Hi, everybody. I'm Susan Abraham, professor of law here at New York Law School and the faculty advisor of the Moot Court Association. And I'm just very excited about the new members that we've gotten through the competition. And I'm very proud of all four of you who I saw argue. I did judge a number of preliminary rounds, and for some reason, even though I judged many, I don't think I judged any of you. So it was a first time for me to see you, and it was really exciting to see what you can do at this very early stage, because I know that you're all going to do so much more by the end of your time on Moot Court. But this is a really exciting time that we're all here together for the first time, and we're all going to be a team, supporting each other, mooting each other, working together on competitions, and I'm really, really excited about it. It was a really close call here in deciding who was the best oralist and who was the best team, because you all did a really good job. And having not seen oral arguments really at all so far, and having any experience in how to do this, it was very impressive. I just want to say a few things about oral argument and give a little feedback about some things that I noticed here and what's really important, which is what we'll all learn during the time on Moot Court. One is responsiveness to the questions of the court. I noticed all four of you at different times didn't respond directly because you weren't sure how to respond. And I just want to remind everybody that when a court asks a question, as Judge Irenas just said to me in the room back there where we were hiding out, it's an opportunity. It feels like a moment, oh no, they're taking me off my planned speech. But you have to take it as a gift, because it's a little window into what's important to the judge. And guess what? What's important to the judge is what's important to you. And even if you didn't think it was important, you've got to stop what you were doing and think about how to answer it directly, and not just talk about a case or not be vague, but say yes or no, Your Honor, and then you can explain. So there were moments when I had to say, so what was your answer to my question? Because it can infuriate a judge to not get a direct answer. And even if it's an answer you don't want to give, you have to give a clear, direct answer before you explain it. And number two, there are opportunities with questions from judges for you as an advocate to concede something. And conceding something that doesn't give up the store, but just is conceding something small. And you can say, yes, Your Honor. It's an opportunity to agree with the judge and develop a relationship and credibility and trust, because an oral argument is a respectful conversation with the court. And the more that you can gain the trust and the confidence of the court, the more you'll be able to persuade that judge. So, for example, when there was a question, something like, well, how many people know what metadata is anyway? That question went out, and I don't even remember which one of you was arguing. It just kind of went, a lot of people know what metadata is, and everyone knows that they give up their privacy. That might have been an opportunity to concede, well, Your Honor, it's true. Many people might not know what metadata is. Gain credibility. You can acknowledge that. You don't have to fight about everything. Give up something you can give up, and then say, but even if they don't know the term metadata, people do understand that their phone numbers, for example, might not be private. So that's a way you can concede something. You're not giving anything up, and you're gaining the trust of the court. One more thing. In terms of really being persuasive, and this would go for the government attorneys, when you kept getting questions on, well, are there any limits? Does the president have broad authority to collect so much private information? And the answers were things like, yes, well, it's only glimpse. They're not getting everybody. That's only 25 million people. I wasn't really feeling it, that was a big limit. And you might do something like come back to the fact that really emphasize that it's metadata. It's not content. There's a huge qualitative difference there. It's not really invading privacy. And sometimes in an oral argument, using an analogy there as another way, it's something you might not do in a brief, but it's more appropriate to an oral argument. If you bring it back to the privacy of the home argument, that people were saying, well, people have a right to the privacy of in their home, what's in their home, and then use that as an analogy for metadata, you might say the metadata is like the outside of their home. What color they painted it, what kind of architecture it is, there's no privacy in that. Everybody knows that you can see the outside of the house when you drive by, and the yard. And that's all metadata is. What's inside the home is content. Or you might compare it to a letter and say the content is the letter. The metadata is the outside of the envelope. And in that way, you make an argument hit home that you're not just using legal terminology and technical language, but you're using an oral argument for a different way of persuading the court. And it's a little bit down home. It's a little bit more conversational. But it's a way that really makes your point. So these are just things that we're all going to be learning. You know, you did a lot of those things at different points of during the argument. You all did them well. But these are just things to think about, how to approach oral argument. But again, I just want to congratulate you. I'm really, really proud of you. I'm really looking forward to working with all of you. And thank you very much.
Justice Slomsky has a few things he would like to say. So
I just wanted to say in the larger sense that the issue of privacy and freedom has been a major issue in American history, not just because of the Internet. I remember when I was in high school, I actually read a book called Privacy and Freedom. And it was written by an author. I even remember his name. His name was Alan Weston, but I can't tell you where he was from. But that issue has never left us. And it's still evolving, and who knows what it's going to be like 60 years or 100 years from now with all the electronic devices that we have. The other thing I want to say is that in my career, I have become somewhat of an expert in electronic surveillance. When I was a young prosecutor, I worked on matters involving electronic surveillance. As judges, we see it because we have to authorize orders to allow electronic surveillance by the government in certain situations. And the issues I was reading about in this case are very related to some of the things we see on a continuing basis as federal judges. And I was, based on my experience, I was fascinated with the questions, and the level of the subject matter here was at a very high level, and I was pleased to see that. There was absolutely nothing frivolous about these arguments.
Thank you. Oh, yes, I have a few comments to make. Just a couple. I've determined that I have a glimpse brain. I read something, and 10 seconds later, I forget what I just read. So I thought it was very appropriate. There's a saying, an old Chinese saying, that when you drink the cold, cool waters of the well, don't forget those who dug the well. And I want to, I know what effort it takes to put together one of these competitions. And there's a lot of, we saw kind of the end product of the process, and we're very happy to see that. But there are a lot of people involved here. You have the draftsman of the fact pattern, which is a very difficult process. Lots of people were involved in it, and those responsible for it did a very good job. There's just the organizing. Remember, this is the last. You have preliminary rounds. We have to recruit judges. And there's lots of work to be done. And it was done, and this law school always does a good job at it. And I want to make sure that we recognize those people who put this all together, the fact pattern, the planning. And I also want to say a special word for Professor Abraham. She's been the one constant, if you will, for at least the 6 or 7 times I've been here. And she just does a wonderful job. She's dedicated to what she does, and she does it well. And so I'd like to hear a hand of applause for all these people. Now, a few comments. One comment I'll repeat, but I always thought of Will Strunk. You know who he is? Strunk. He wrote the little book, the famous little book on grammar. Strunk and, well, it became Strunk and White. It was originally written just by Will Strunk, who was a professor of English at Cornell. White, E.B. White, later joined it and when after Strunk died and did a very famous preface to it as well as doing some revisions. But Strunk said, "Don't compound ignorance with inaudibility." It is important. Other people have said this, so I'm repeating what the other justices have said. But keep your voice up. Speak. I hate to say speak with authority, but speak with confidence and firmness. If you sound tentative to the judges, they are going to less respect your whatever it is argument you're making. It's just going to be that way. On the other hand, there's a contrary kind of the other side of that coin, if you will, which is was taught to me by a judge from Alabama, believe it or not, from the Middle District of Alabama, who was also a two-star general. But he said, you never argue with a judge, you argue to a judge. And that's very, very important. If you're going to argue with a judge, you're going to lose. Simple as that. If you argue to a judge, well, that's what you're supposed to do. You're supposed to argue to a judge. I recently, the case eventually crumbled, but I was in the middle of a very high-profile case. And the lawyer for the defendant was a member of a firm, or most of the members of the firm were clerks to the United States Supreme Court, just to give you an idea of the type of firm. And they do a lot of white-collar. They're from Washington. They do a lot of white-collar work. I could bombard this guy with the worst ruling he could possibly ask for, and he'd get up and he'd act like he won. He didn't betray. Not only did he betray any being upset that I had just bombed one of his arguments. If you listen to him and you listen to his tone of voice, you think he had won the argument. I'm listening. Didn't I just decide against you? And there he's thanking me, and you know. But that was a very good quality, and he was a very great lawyer. So always keep that in mind. And this is not, by the way, this is not a criticism of anybody's particular argument. I'm just using this occasion to give you a pet peeve of mine. And none of you did that. In fact, I think you were all strong, and all four of you were strong in not trying to pitch yourself to argue with this panel of judges. I think you were all good at that, and to try to make an argument to us as to why we should go a certain way or think a certain thing. But I think you all did it without crossing the level where you were no longer arguing to us, but you were arguing with us. And I don't think any of you ever reached that point, and to that I congratulate all four of you. Again, you heard, and I'll repeat it because I think it's so important, that a question by a judge should be looked at as an opportunity and not as something where you have to be afraid that your well-prepared argument is being shattered. You're getting a window into what's on the judge's mind, and you should just look at it as an opportunity, not as a place to run and hide or a cause to run and hide, but a place to step up and try to kind of think of what is the judge looking for, and can I give him or her what she's looking for. And I can't emphasize that enough, because this is my 24th year at this job, and I can tell you, and I like oral argument, by the way. I have to confess that in the federal courts, there is a trend, in a sense, against oral argument, which I don't like. I allow oral argument in about every motion.
I do the same.
Yeah,
I do the same.
I tend to learn a lot in oral argument. I learn where the lawyer's heart is really beating. what is it that's really got under his skin or her skin? And so I'm a fan. We have a few judges, even in my district, who don't almost never allow oral argument unless you plead for it. And I think that's a mistake. I think oral argument is very valuable. And I'm happy to be here before 4 individuals who clearly will be outstanding when their turn comes in state or federal court to present arguments. It was a close call. You all did a great job. Again, the people who put this whole program together, and Professor Abraham, who is the spiritual advisor of this effort. I'm not going to say what religion it is, but she's the spiritual advisor, and everyone is to be very proud. And let me have one more hand of applause for everybody that put this together.
I just want to say really thank you so much to our judges who have volunteered to take off their time on a Sunday afternoon, not to mention all the time it took them to prepare, which clearly all of them did. Judge Soto, Judge Slomski, and Judge Irenas for being so helpful in guiding us as Moot Court Association students and coming back and really giving their time to this community. We really, really appreciate it. So thank you.
Following Professor Abraham's remarks, we truly thank every one of you, Judge Soto, Judge Slomski, and Judge Irenas, for taking time out of your day to come judge the final round. Another round of applause. We will now acknowledge every competitor here who has been invited to join the Moot Court Association. We ask that you please hold your applause till the end, so we could just congratulate everyone all together. Gabriela Ali Marino, Walid Amer, Stephanie Baer, Eric Bensenberg, Andre Cleghorn, Ronald Cosme, Famara Kante, Ariana Dindial, Kayla Espinosa, Alyssa Feldman, Luisa Flores, Alexis Granell, Vanessa Marston.
Jeffrey Wolber, Lena Godo, Leah Henry, Dale Mackey, Molly Mock, Joshua Mitz, Sherboon Paul, Alexander Rockoff, Andrew Ruggiero, Joshua Satter, Amanda Seelman, Jason Singer, Fumiko Takada, Kevin Timpone, and Rachel Searle.
We will now announce the 4 awards that we award to students prior to the final round. So for Best Petitioner Brief, we have Molly Mock. Now for Best Respondent Brief, we have Sherboon Paul and Leah Henry.
For the Best Preliminary Round Oralist, we have Dale Mackey.
Congratulations.
Thank you.
And for best team, we have Sharboon Paul and Leah Henry. Congratulations. Okay.
Thank you.
Then we have just these.
And now, best final round oral advocate, Ronald Cosme.
Congratulations.
And now for all the finalists, competitors, Molly Mock, Eric Bensenberg, and Joshua Mitz, can you please come up? Congratulations.
Thank you.
Congratulations. Yeah. Thank you so much, everyone, for coming. And now.